Do your own wills are recognized. While you are free to do your own, there are still statutory requirements for what a will has to have in order for it to be considered valid. The big one being it has to be signed in the presence of 2 witnesses. So one of the biggest issues I see with clients that ultimately decide to do their own wills is that they go online and they print off a will and they sign it and they don't get the witnesses, or they print it off and then they never even sign it. So it's just, there are still formalities that need to be abided by. One of the documents that we do as part of an estate planning is a healthcare directive and living will, which the healthcare directive appoints who you want your medical decision maker to be if you can't make decisions for yourself. And the living will, as I mentioned, kind of describes what type of treatment you don't want to receive at the end of your life. The DNR is a document that can only be prepared by a physician. So that's nothing that an attorney can prepare in advance. It can only be prepared by the doctor after a conversation with them, which talks about the same things that a living will does. The doctor will ask what type of treatment do you want or do not want to receive, but then that's something the doctor puts directly into your medical chart. So if a doctor comes into your room and you're having health issues, they look at that and they see that you've elected not to receive CPR, so they'll know right away that they're not going to do that. Whereas the living will, the document that we would prepare on the legal side of things, to some extent just puts the doctors on notice as to the type of care you don't want to receive. But when the time comes to decide whether or not they're going to administer that care, they talk to your healthcare representative or your substitute medical decision maker and make them decide what they should or should not do.